policy. In this particular case, since we've been focused on it so much, we took a look at it, and there are any number of reasons why there's a problem with this public policy argument. First, that argument was not raised below. They did not raise any argument that public policy is a question that should be considered by the court in terms of voiding the contract. Second, it's a speculative claim, Your Honor. That is to say, we have no idea, frankly, I have no idea how this might work out, whether it's better or worse under, and again, it's not the Georgia wrongful death statute. What counsel is alluding to is the modified comparative fault measure that is applied under Georgia law. And frankly, under those circumstances, it's sheer speculation to say whether that would help or hurt, in this particular instance, Mrs. Sachs's claim. But we also question whether there would be a strong public policy for a Florida court to provide the Florida wrongful death statute benefit, whatever it may be, to a Colorado decedent's personal representative under these circumstances with a contract the decedent signed unequivocally in multiple places, acknowledging that he understood in the event that a claim be made that it would be made under Georgia law. Finally, there's no case, none whatsoever, that's cited in the appellee's brief that suggests that somehow or another this would be violative of public policy. He does cite to a number of these nursing home cases that you all have had to be involved with, and there the circumstances in fact are quite different. There the issue is that the legislature passed a law that had some specific benefits in it, and then essentially a segment of industry, the nursing home business, attempted to contract around those provisions. That's simply not true here. Finally, we actually found a case from the Florida Supreme Court called Hopkins against Lockheed at 201 Southern 2nd 743. It really isn't on.
Is that cited in your brief?
I don't believe so. I don't believe it is.
You can't really argue. But if you have that for supplemental authority, would you supply it to us?
I will.
Thank you.
And in that context, we think that the law is crystal clear that even where another state's wrongful death statute, for example, would substantially limit the amount that could be recovered, in that particular instance, a $30,000 limit, the Supreme Court did not conclude that that was antithetical to public policy here in Florida. So for all those reasons, we think the public policy issue, beginning with it wasn't raised below, is kind of a red herring in these questions. But the simple fact is, as Your Honor pointed out from the very beginning, no evidence whatsoever was taken in this case. There is no question that the law requires that evidence be provided. In our view, we think that the problem there was that was error. It's clear to us that that was error, and it was error invited by the appellee. In the appellee's original answer brief, and in this reply brief that we think was inappropriate but was nonetheless filed, in both instances, appellee suggests no need to take evidence whatsoever. Don't have to have any evidence under these circumstances. And that, we think, invited the error by the trial court to conclude that this contract was unconscionable procedurally and substantively with no evidence whatsoever.
Okay, thank you. You've already gone over, and I'm going to give you a couple more minutes, so we'll hear from you. Okay.
Thank you, Your Honor.
Thank you.
May it please the Court, Jonathan Yellen from the Yellen Law Firm with Claudine Burke, my firm as well, on behalf of the appellees, Mrs. Sachs, on behalf of the estate of Brian Sachs. Your Honors, what we have today is a case of an arbitration clause and a waiver, which is not a contract. And we have appellants that are trying to cram it into the box of a contract, trying to apply contractual terms to it, but it really isn't a contract. It contains no terms, as Your Honor Warner picked up on it. It has nothing in it that otherwise specifies any of the obligations of the parties. All it says is that Mr. Sachs will give all of his rights to ATP.
Yeah, but where is that in the record?
That is actually...
Where did Judge Crathan make that determination?
Judge Crathan found, actually, in reviewing the entire document, that the entire document does shift all of the benefits to ATP, and that's why he
didn't he use the term totality of the circumstances?
Yes.
Yeah, but what circumstances?
It's all of what's actually in the document. It's Jacksonville being the venue, it's the application of Georgia law for no reason whatsoever, and that's not explained in the record. To this day, we have no reason why.
Yeah, but in order for the judge to reach the conclusion that it was unconscionable, it seems to me that if you just look at this contract, I'm not sure just by virtue of the fact that you're going to apply Georgia law or that you're going to have venue in Jacksonville, Florida, particularly when apparently the defendant has its principal place of business there in Florida, that's per se unconscionable. I mean, that doesn't make sense to me.
Well, there was another issue and another factor that the court had considered, which is that only ATP was allowed to call for arbitration. In the totality of the circumstances that Judge Crathan was referencing, he was looking at the fact that only ATP can call for arbitration and not Mr. Sachs in the event of an incident. Only ATP, therefore, could choose Jacksonville as its venue, and only ATP could choose the application of Georgia law. If ATP didn't want to, ATP could say, we don't want to arbitrate. We want this to happen in Broward County or wherever if they thought that Florida law was somehow more beneficial than Georgia law.
So you're saying there was no mutuality of remedy?
There's no mutuality of remedy. That doctrine has actually been eroded quite a bit over the years, and that's why we have not really gone there all the way. It's an issue, it's sort of out there, but the better and preferred way to approach mutuality of remedy under the case law is to look at it under the conscionability issue. That's what the courts are doing. So you can still look at what the court is considering and what Judge Crathan considered, but the better way to do it is under the conscionability analysis.
Doesn't that require, though, some evidence? I mean, you put on no evidence.
You're right, Your Honor. It doesn't require evidence to the extent that thus far in the record, all that they're alleging, for instance, with respect to Mr. Sachs' residency as a Colorado resident, I mean, the fact that there's no record doesn't really help either side in any one particular way, because many of the arguments that they make are completely dependent upon record evidence. So to the extent that all we have is an arbitration agreement, and all we
you have the burden to establish unconscionability before the trial court.
You're absolutely right, and we're able to do that with the two prongs of unconscionability being procedural and substantive. Okay, we're looking at it from a procedural perspective. It's a contract of adhesion. There was no opportunity to negotiate the contract, and the case law is clear.
But how do we know that? Nobody came in and testified as to how this document was executed and under what circumstances. Well, I didn't see anything.
I think it can be inferred from the record, Your Honor, that it was a standard flight school one-page agreement that was otherwise presented to Mr. Sachs 3 days.
That's a pretty large inferential leap. I mean, if there's nothing in the record and we don't know under what circumstances this gentleman signed this document, how do we reach that conclusion? Well, how do you infer? What are you inferring from?
I understand the court's concerns, and that's what I'm sorry.
Just to follow up with Judge Morgan, then if we were to accept that, then as a matter of law, all these type of contracts with these type of provisions would all be unconscionable.
Not necessarily, Your Honor. What you have is it's just one piece of the pie. Under the case law, in order to establish procedural unconscionability, which is what Judge Morgan is referencing, you only need, I think the case law uses the word mediocre, or it's only a scintilla.
Well, no, it's a weighing between the two of them.
Absolutely.
If you've got a whole bunch of substantive unconscionability, then you only need a little bit of the other. But if you, so far, you haven't shown us that you have either.
And if that's the court's concern, there's also case law holding that the case can be remanded back to the trial court to develop in discovery, and the court has actually done that in some cases, to develop whether that exists. I know in my head, and I'm not going to stand here and represent something that's not in the record, but I know that if that's what happens in this case, it's not going to turn out very well for them.